It's time to get nerdy, y'all.
A little bit of gaming history for you.
Something relevant in gaming and discuss our opinions on it.
Should we kick it out of here, or should we kick-start it?
This is the part where you, the listeners, try to stump the hosts.
I'm not a lawyer, I just play one on a podcast. Ladies and gentlemen, a special treat for you today. It's often referenced on this show that video games are art, and we've talked about on the show how that came about. The case was Brown v. Entertainment Merchants Association, and the ruling was given in 2011. Now, we've already heard part 1 of 4, which was the majority opinion written by Scalia. And what I have for you today is part 2 of 4, which is Alito's concurrence, to which Chief Justice Roberts signed on. So, let's hop in and see if we can't learn a little bit more about what these people thought about these video games. The California statute that is before us in this case represents a pioneering effort to address what the state legislature and others regard as a potentially serious social problem: the effect of exceptionally violent video games on impressionable minors who often spend countless hours immersed in the alternative worlds that these games create. Although the California statute is well-intentioned, its terms are not framed with the precision that the Constitution demands, and I therefore agree with the court that this particular law cannot be sustained. I disagree, however, with the approach taken in the court's opinion. In considering the application of unchanging constitutional principles to new and rapidly evolving technology, this court should proceed with caution. We should make every effort to understand the new technology. We should take into account the possibility that developing technology may have important societal implications that will become apparent only with time. We should not jump to the conclusion that new technology is fundamentally the same as some older thing with which we are familiar, and we should not hastily dismiss the judgment of the legislatures, who may be in a better position than we are to assess the implications of new technology. The opinion of this court exhibits none of this caution. In the view of the court, all those concerned about the effects of violent video games, federal and state legislators, educators, social scientists, and parents, are unduly fearful, for violent video games really present no serious harm. Spending hour upon hour controlling the actions of a character who guns down scores of innocent victims is not different in kind from reading a description of violence in a work of literature. The court is sure of this. I am not. There are reasons to suspect that the experience of playing violent video games just might be very different from reading a book, listening to the radio, or watching a movie or a television show. 1. Respondents in this case, representing the video game industry, ask us to strike down the California law on 2 grounds: the broad ground adopted by the court, and the narrower ground that the law's definition of a violent video game is impermissibly vague. Because I agree with the latter argument, I see no need to reach the broader First Amendment issues addressed by the court. A. Due process requires that laws give people of ordinary intelligence fair notice of what is prohibited. The lack of such notice in a law that regulates expression raises special First Amendment concerns because of its obvious chilling effect on free speech. Reno v. ACLU, 1997. Vague laws force potential speakers to steer far wider of the unlawful zone than if the boundaries of the forbidden areas were clearly marked. Baggett v. Bullitt, 1964. While perfect clarity and precise guidance have never been required, even of regulations that restrict expressive activity, Ward v. Rock Against Racism, 1989, government may regulate the area of First Amendment freedoms only with narrow specificity. NAACP v. Button, 1963. These principles apply to laws that regulate expression for the purpose of protecting children. Here, California law does not define violent video games with the narrow specificity that the Constitution demands. In an effort to avoid First Amendment problems, the California legislature modeled its violent video game statute on the New York law that this court upheld in Ginsburg v. New York, a law that prohibited the sale of certain sexually related materials to minors. But the California legislature departed from the Ginsburg model in an important aspect, and the legislature overlooked important differences between the materials falling within the scope of the two statutes. B. The law at issue in Ginsburg prohibited the sale to minors of materials that were deemed harmful to minors, and the law defined harmful to minors simply by adding the words for minors to each element of the definition of obscenity set out in what were then the court's leading obscenity decisions, Roth v. United States, 1957, and book named John Cleland's Memoirs of a Woman of Pleasure v. Attorney General of Massachusetts, 1966. Seeking to bring its violent video game law within the protection of Ginsburg, the California legislature began with the obscenity test adopted in Miller v. California in 1973, a decision that revised the obscenity tests previously set out in Roth and Memoirs. The legislature then made certain modifications to accommodate the aim of the violent video game law. Under Miller, an obscenity statute must contain a threshold limitation that restricts the statute's scope to specifically described hardcore materials. Materials that fall within this hardcore category may be deemed to be obscene if 3 additional requirements are met. 1. An average person applying contemporary community standards must find the work, taken as a whole, appeals to the prurient interest. 2. The work must depict or describe in patently offensible way sexual conduct specifically defined by the applicable state law. And 3. The work, taken as a whole, must lack serious literary, artistic, political, or scientific value. Adapting these standards, the California law imposes the following threshold limitation. The range of options available to a player must include killing, maiming, dismembering, or sexually assaulting an image of a human being. Any video game that meets this threshold test is subject to the law's restrictions if it also satisfies the 3 further requirements. 1. A reasonable person considering the game as a whole would find the game appeals to a deviant or morbid interest of minors. 2. It is patently offensive to prevailing standards in the community as to what is suitable for minors. 3. It causes the game as a whole to lack serious literary, artistic, political, or scientific value for minors. C. The first important difference between the Ginsburg law and the California violent video game statute concerns their respective threshold requirements. As noted, the Ginsburg law is built upon the test for adult obscenity, and the current adult obscenity test, which was set out in Miller, requires an obscenity statute to contain a threshold limitation that restricts the statute's coverage to specifically defined hardcore depictions. The Miller court gave, as an example, a statute that applies to only patently offensive representations or descriptions of ultimate sexual acts. The Miller court clearly viewed this threshold limitation as serving a vital notice function. "We are satisfied," the court wrote, "that these specific prerequisites will provide fair notice to a dealer in such materials that his public and commercial activities may bring prosecution." By contrast, the threshold requirement of the California law does not perform the narrowing function served by the limitation in Miller. At least when Miller was decided, depictions of hardcore sexual conduct were not a common feature of mainstream entertainment. But nothing similar can be said about much of the conduct covered by the California law. It provides that a video game cannot qualify as violent unless the range of options available to a player includes killing, maiming, dismembering, or sexually assaulting an image of a human being. For better or worse, our society has long regarded many depictions of killing and maiming as suitable features of popular entertainment, including entertainment that is widely available to minors. The California law's threshold requirement would more closely resemble the limitation in Miller if it targeted a narrower class of graphic depictions. Because of this feature of the California law's threshold test, the work of providing fair notice is left in large part up to the 3 requirements that follow, but those elements are also not up to the task. In drafting the violent video game law, California legislature could have made its own judgment regarding the kind and degree of violence that's acceptable in games played by minors, or by minors in particular age groups. Instead, the legislature relied on undefined societal or community standards. One of the 3 elements at issue here expressly refers to prevailing standards in the community as to what is suitable for minors. Another element points in the same direction, asking whether a reasonable person, considering the game as a whole, would find that it appeals to a deviant or morbid interest of minors. The terms deviant and morbid are not defined in the statute, and California offers no reason to think that its courts would give the terms meanings anything other than the ordinary meaning. I therefore assume that deviant and morbid carry the meaning that they convey in ordinary speech. The adjective deviant ordinarily means deviating from some accepted norm, and the term morbid means of relating to or characteristic of a disease. A deviant or morbid interest in violence, therefore, appears to be an interest that deviates from what is regarded, presumably in accordance with some generally accepted standard, as normal and healthy. Thus, the application of the California law is heavily dependent on the identification of a generally accepted standards regarding the suitability of violent entertainment for minors. The California legislature seems to have assumed that these standards are sufficiently well known so that a person of ordinary intelligence would have fair notice as to whether the kind and degree of violence in a particular game is enough to qualify the game as violent. And because the Miller test looks to community standards, the legislature may have thought that the use of undefined community standards in the violent video game law would not present a vagueness problem. There is a critical difference, however, between obscenity laws and laws regulating violence in entertainment. By the time of this court's landmark obscenity cases in the 1960s, obscenity had long been prohibited, and this experience had helped to shape certain generally accepted norms concerning expression related to sex. There is no similar history regarding expression related to violence. As the court notes, classic literature contains descriptions of great violence, and even children's stories sometimes depict very violent scenes. Although our society does not generally regard all depictions of violence as suitable for children or adolescents, the prevalence of violent depictions in children's literature and entertainment creates numerous opportunities for reasonable people to disagree about which depictions may excite deviant or morbid impulses. Finally, the difficulty of ascertaining the community standards incorporated into the California law is compounded by the legislature's decision to lump all minors together. The California law draws no distinction between young children and adolescents who are nearing the age of majority. In response to a question at oral argument, the attorney defending the constitutionality of the California law said that the state would accept a narrowing construction of the law under which the law's references to minors would be interpreted to refer to the oldest minors, that is, those short of 18. However, it is not within our power to construe and narrow state laws. We can only extrapolate their allowable meaning from the statutory text and authoritative interpretations of similar laws by courts of the state. In this case, California has not provided any evidence that the California legislature intended the law to be limited in this way, or cited any decisions from its courts that would support an oldest minors construction. For these reasons, I conclude that the California violent video game law fails to provide the fair notice that the Constitution requires, and I would go no further. I would not express any view on whether or not a properly drawn statute would or would not survive First Amendment scrutiny. We should address that question only if and when it is necessary to do so. 2. Having outlined how I would decide this case, I now briefly elaborate on my reasons for questioning the wisdom of the court's approach. Some of these reasons are touched upon by the dissents, and while I am not prepared at this time to go as far as either Justice Thomas or Justice Breyer, they raise valid concerns. A. The court is wrong in saying that the holding in United States v. Stevens 2010 controls this case. First, the statute in Stevens differed sharply from the statute at issue here. Stevens struck down a law that broadly prohibited any person from creating, selling, or possessing depictions of animal cruelty for commercial gain. The California law involved here, by contrast, is limited to the sale or rental of violent video games to minors. The California law imposes no restriction on the creation of violent video games or on the possession of such games by anyone, whether above or below the age of 18. The California law does not regulate the sale or rental of violent games by adults. and the California law does not prevent parents and certain other close relatives from buying or renting violent video games for their children or young relatives if they see fit. Second, Stevens does not support the proposition that a law like the one at issue must satisfy strict scrutiny. The portion of Stevens on which the court relies rejected the government's contention that depictions of animal cruelty were categorically outside the range of any First Amendment protection. Going well beyond Stevens, the court now holds that any law that attempts to prevent minors from purchasing violent video games must satisfy strict scrutiny instead of the more lenient standard applied in Ginsburg, our most closely related precedent. As a result of today's decision, a state may prohibit the sale to minors of what Ginsburg described as girly magazines, but a state may surmount a formidable and perhaps insurmountable obstacle if it wishes to prevent children from purchasing the most violent and depraved video games imaginable. Third, Stevens expressly left open the possibility that a more narrowly drawn statute targeting depictions of animal cruelty might be compatible with the First Amendment. In this case, the court's sweeping opinion will likely be read by many, both inside and outside the video game industry, as suggesting that no regulation of minors' access to video games is allowed, at least without supporting evidence that may not be realistically obtainable given the nature of the phenomenon in question. B. The court's opinion distorts the effect of the California law. I certainly agree with the court that the government has no free-floating power to restrict the ideas to which children may be exposed, but the California law does not exercise such a power. If parents want their children to have a violent video game, the California law does not interfere with that parental prerogative. Instead, the California law reinforces parental decision-making in exactly the same way as the New York statute upheld in Ginsburg. Under both laws, minors are prevented from purchasing certain materials, and under both laws, parents are free to supply their children with these items if that is their wish. Citing the video game industry's voluntary rating system, the court argues that California law does not meet a substantial need of parents who wish to restrict their children's access to violent video games but cannot do so. The court does not mention the fact that the industry adopted this system in response to the threat of federal regulation, a threat that the court's opinion may now be seen as largely eliminating. Nor does the court acknowledge that the compliance with this system at the time of the enactment of the California law left much to be desired, or that future enforcement may decline if the video game industry perceives that any threat of government regulation has vanished. Nor does the court note, as Justice Breyer points out, that many parents today are simply not able to monitor their children's use of computers and gaming devices. C. Finally, the court is far too quick to dismiss the possibility that the experience of playing video games, and the effects on minors of playing violent video games, may be very different from anything that we've seen before. Any assessment of the experience of playing video games must take into account certain characteristics of the video games that are now on the market and those that are likely to be available in the near future. Today's most advanced video games create realistic alternative worlds in which millions of players immerse themselves for hours on end. These games feature visual imagery and sounds that are strikingly realistic, and in the near future, video game graphics may be virtually indistinguishable from actual video footage. Many of the games already on the market can provide high-definition images, and it is predicted that it will not be long before video game images will be seen in 3 dimensions. It is also forecast that video games will soon provide sensory feedback. By wearing a special vest or other device, a player will be able to experience physical sensations supposedly felt by the character on the screen. Some amici who support respondents foresee the day when virtual reality shoot-'em-ups will allow children to actually feel the splatting blood from the blown-off head of a victim. Persons who play video games also have an unprecedented ability to participate in the events that take place in the virtual worlds that these games create. Players can create their own video game characters and can use photos to produce characters that closely resemble actual people. A person playing a sophisticated game can make a multitude of choices that can thereby alter the course of the action in the game. In addition, the means by which players control the action in video games now bear a close relationship to the means by which people control action in the real world. While the action in older games was often directed with buttons or a joystick, players dictate the action in newer games by engaging in the same motions that they desire a character in the game to perform. For example, a player who wants a video game character to swing a baseball bat, either to hit a ball or smash a skull, could bring that about by simulating the motion of actually swinging a bat. These present-day and emerging characteristics of video games must be considered together with characteristics of the violent video games that have already been marketed. In some of these games, the violence is astounding. Victims by the dozens are killed with every imaginable implement, including machine guns, shotguns, clubs, hammers, axes, swords, and chainsaws. Victims are dismembered, decapitated, disemboweled, set on fire, and chopped up into little pieces. They cry out in agony and beg for mercy. Blood gushes, splatters, and pools. Severed body parts and gobs of human remains are graphically shown. In some games, points are awarded based not only on the number of victims killed, but on the technique employed. It also appears that there is no antisocial theme too base for some in the video game industry to exploit. There are games in which a player can take on the identity and reenact the killings carried out by the perpetrators of the murderers at Columbine High School and Virginia Tech. The objective of one game is to rape a mother and her daughters. In another, the goal is to rape Native American women. There is a game in which players engage in ethnic cleansing and can choose to gun down African Americans, Latinos, or Jews. In still another game, players attempt to fire a rifle shot into the head of President Kennedy as his motorcade passes by the Texas School Book Depository. If the technical characteristics of the sophisticated games that are likely to be available in the near future are combined with the characteristics of the most violent games already marketed, the result will be games that allow troubled teens to experience in an extraordinary, personal, and vivid way what it would be like to carry out unspeakable acts of violence. The court is untroubled by this possibility. According to the court, the interactive nature of video games is nothing new because all literature is interactive. Disagreeing with this assessment, the International Game Developers Association, a group that presumably understands the nature of video games that supports respondents, tells us that video games are far more concretely interactive. And on this point, the game developers are surely correct. It is certainly true, as the court notes, that literature, when it is successful, draws the reader into the story, makes them identify with the characters, invites her to judge them, and quarrel with them to experience their joys and sufferings as the reader's own. But only an extraordinarily imaginative reader who reads a depiction of a killing in a literary work will experience that event as vividly as he might if he played the role of the killer in a video game. To take an example, think of a person who reads the passage in Crime and Punishment in which Raskolnikov kills the old pawnbroker with an axe. Compare that reader with a video game player who creates an avatar that bears his own image, who sees a realistic image of the victim and the scene of killing in high definition and in 3 dimensions, who is forced to decide whether or not to kill the victim and decides to do so, who then proceeds to grasp the axe, raise it above the head of the victim, and then to bring it down, who hears the thud of the axe hitting the head, the cry of pain, who sees the split skull and feels the sensation of blood on his face and hands. For most people, the two experiences will not be the same. When all of the characteristics of video games are taken into account, there is certainly a reasonable basis for thinking that the experience of playing a video game may be quite different from the experience of reading a book, listening to a radio broadcast, or viewing a movie. And if this is so, then for at least some minors, the effects of playing violent video games may be quite different. The court acts prematurely in dismissing this possibility out of hand. For all these reasons, I would hold only that the particular law at issue here fails to provide clear notice that the Constitution requires. I would not squelch legislative efforts to deal with what is perceived by some to be a significant and developing social problem. If differently framed statutes are enacted by the states or by the federal government, we can consider the constitutionality of those laws when cases challenging them are presented to us. All right. With the conclusion of Alito's concurrence, we are now halfway through the opinions of Brown v. Entertainment Merchants Association. Now, if you enjoyed that, you won't want to miss next time, because Justice Thomas's dissent is interesting, to say the least. Thanks for listening, be excellent to each other, and keep it nerdy.